The students, alterations of memorandum of association is also a very important aspect. In my last video, I have discussed the memorandum of association, its importance, its meaning, and also what are the clauses it is having. Now the question is, can we alter memorandum of association? While explaining its importance, I have mentioned the fact that memorandum of association is very important document. It is just like constitution of the company. So it is unalterable document. But in few cases, some of the items or some of the aspects, some of the points can be altered. But the alteration is not easy task. Alteration has got its own procedural aspect, and all those procedures are to be followed for altering the memorandum of association. Section 16 of the Act provides that a company shall not alter the conditions contained in its memorandum except in the cases, in the manner, and to the extent provided in the Act. Name clause. How can it be altered? When can it be altered? Is it possible? How you can alter? Name of a company can be altered in 3 different situations. First one, when the name of the company is similar to that of the existing company. By mistake, you have kept a name which is already there in some other company. Then you have to change it. If all the shareholders require a change in the name, all the shareholders feel that the name is not good or it is not suitable or it is not proper, they want to change the name. When the central government directs to change its name, central government sometimes feel that the name is against to the wishes, against to the conditions of the nation. So it feels that the name has to be changed. In such a situation, it has to be changed. Then first case, that is similar name, when the identical name is there already for the existing company. If a company has a name similar to another existing company, it has to be changed by passing an ordinary resolution. Ordinary resolution, I hope you know, ordinary resolution is to be passed in general meeting of the company, wherein all the shareholders should be present, and the resolution should be voted by majority, that is 51, minimum 51% of the members present in the meeting. That is called as ordinary resolution. Prior approval of central government is needed because the name, what new name is going to be given to the company, whether it is okay or not, whether this name can be kept for the company or not, the inquiry has to be made. So the approval from central government is needed. Resolution is to be filed with the registrar to get certificate of incorporation in new name, because already one certificate we have taken, but it is in the earlier name. Now the name is being changed, so new certificate is to be taken. Then sometimes when the central government directs the company to change its name, ordinary resolution should be passed in extraordinary meeting. Why extraordinary meeting? Extraordinary general meeting is one which is undertaken between 2 general meetings. So already last year's general meeting is over, and we need not wait for the next general meeting, which is going to be undertaken after completion of 1 year from the earlier meeting. So extraordinary general meeting for the special matter is to be conducted, and in that meeting ordinary resolution is to be passed, and the central government already directed to change the name, so we have to make it. Resolution is to be filed with the registrar to get certificate of incorporation in a new name. Shareholders, when all the shareholders wish to change the name, then when shareholders of the company wish to change its name, then general meeting is to be called for. Special resolution should be passed. Special resolution means ordinary resolution needs minimum 51, that is simple majority. But for special resolution, 3/4 of the, that is 75% of the shareholders should give consent. 3/4 majority is needed. then only the resolution is passed. That is called a special resolution. So extraordinary general meeting is to be called, because we can't wait till the general meeting, which is going to come after 1 year. So we are conducting extraordinary general meeting, and in that we have to go for special resolution with 3/4 majority. Resolution should be filed with the registrar. Prior approval of central government is also necessary, because the new name, whether it is okay or not, whether it is objectionable, whether it is the name of already existing company, we should make inquiries. For that, we should take the prior approval of central government. So this is about the name clause. What is second clause? Second clause, that is domicile clause or registered office clause. So in this, if we want any alteration, it may be of 3 types. First one, shifting from one locality to another within the same city. For example, if the company is situated in Bangalore or in Hubli, and it now changing its office from one locality to another within the same city, how it is possible? What are the procedure for the same? This is the first situation. And second situation is about shifting from one city to another within same state. Here, the company is shifting its office from one town, one city to another, but within the same state. For example, within the Karnataka itself, if earlier company is having its office in Hubli and now it's shifting from Hubli to Bangalore, then this is second case. And in third case, shifting from one state to another. That means from Karnataka to Andhra Pradesh or Maharashtra, from Karnataka to Tamil Nadu, or from Karnataka to Kerala. If it is shifting from one state to another, what is the procedure? Whether it is approved or not, whether it is okay or not. Let us understand one after the other. First one is shifting from one locality to another within the same city. Here, locality is different, but the city is the same. So for this board meeting, that is not the shareholders, only directors meeting, that is board meeting, is to be convened, and they have to discuss, all the directors will discuss about it, and the resolution of directors is to be passed, and new address should be filed with the registrar within 30 days. So registrar should be informed about its new address. Just we have to give the information. We need not take the permission, because it is shifting from one locality to another within the same city. So even you need not inform it to, you need not take the resolution in general meeting, or you need not conduct the general meeting of shareholders, because we are not changing the city. So only director meeting is enough. Director meeting resolution is enough, and it should be intimated to all the members. No doubt about it. We have to intimate them. We have to just give them the information about it. But when you are changing the city, you have to ask your shareholders whether it is okay or not, whether they give the consent or not. So general meeting of shareholders is to be conducted. Obviously, it is extraordinary general meeting, because we cannot wait up to annual general meeting. So one quick meeting has to be conducted, that is extraordinary general meeting. And once again, just observe here, special resolution, that means 3/4 of the majority is to be taken. Special resolution is to be passed in the meeting, means more than 75% of the shareholders should give the consent. Copy of resolution is to be filed with the registrar within 30 days, and you have to shift. But how about shifting from one state to another? Is it okay? Section 17 of Indian Companies Act tells you about it. General meeting of shareholder is to be held. Special resolution is to be passed. As I have already mentioned, special resolution means 3/4 majority in the general meeting is to be taken, and confirmation order is to be obtained by company law board. Company law board, you should give the application to company law board whether you can change your state. Is it okay? You have to take the confirmation order. You have to take the consent. Certified copies of resolution, confirmation order should be submitted to the registrar of both the states. That is, suppose if you are changing your office from Karnataka to Andhra Pradesh, then you have to take the permission from both the states. Here in one office, you have to submit the certified copies of resolution confirmation order. Here in Karnataka, then the same thing, same set of documents should be submitted to the office which is situated in Andhra Pradesh, along with the altered copies of memorandum. So you have to alter your memorandum. We have especially that is all the clauses are same, but here domicile clause is changed. So the changed domicile clause means changed new memorandum needs to be prepared and you should submit it with the registrar. Whether you can change the country, change outside India. Can you shift your office from India to Hong Kong? Can you change your office from India to USA? Is it possible to change from India to Pakistan or China? A company cannot change its registered office from India to another country, and central government has no power to change memorandum for that matter. So you should observe it that once you have registered your company in India, you should have the head office here itself. You can extend your business. You can have several branches in different countries. You can have any type of business you can do. You can export, you can import, you can have your services there. You can have showrooms, you can have retail outlets or manufacturing unit or purchasing unit, whatever the expansion is permitted. But the head office or the registered office should not be shifted. Company can change the place of its registered office from one place to another within a state if the regional director confirms it. For this purpose, the company has to make an application to the regional director for confirmation. This confirmation shall be communicated to the company within 4 weeks. The company shall then file with the registrar a certified copy of the confirmation by the regional director within 2 months from the date of confirmation, together with a printed copy of the memorandum of association as altered. The registrar shall register the same within 1 month from the date of filing of such a document. The change of registered office from one state to another state involves alteration of memorandum, and the change can be effected by special resolution of the company, which must be confirmed by the central government. Following procedure should be followed for this purpose. That is, special resolution must be passed. Copy of the special resolution should be filed with the registrar within 1 month, that is 30 days. Alteration to be confirmed by the central government. A certified copy of the central government's order and a copy of the altered memorandum should be filed with the registrar within 3 months. So this is about the alteration of name clause and also domicile clause. Now let us think of the alteration of object clause, whether it is permitted or not. Object clause can be altered to a limited extent. Slight changes can be taken place to enable the company to do the following: to carry on its business more economically or efficiently, to attain its purpose by new and improved means, to enable or change its local area of operations. Only this kind of permission is allowed. A special resolution should be passed in the general meeting. Confirmation order of company law board is to be obtained. Confirmed copy of confirmation order and revised memorandum of association are submitted to the registrar. This is the procedure, how it is to be taken. So you have to conduct the general meeting, then you have to take the special resolution there, and you have to file one application to the company law board, and company law board has to give you the confirmation order. It takes time, After this confirmation copy obtaining and after passing the special resolution, then you can change your memorandum of association and the revised copy will be submitted to the registrar. To carry on some business which can be conveniently combined with the present business of the company, to restrict any of the objects specified in the memorandum, to sell or dispose of the whole or any part of the understanding of the company, to amalgamate with any other company. These are permitted. Only these are permitted. So otherwise, the object clause cannot be changed. And how about alteration of liability clause? Liability of members cannot be changed. Okay, it cannot be changed. But liability of directors can be increased. You can increase the director's liability. You cannot decrease it. by passing a special resolution provided the directors give their consent. But think of the situation whether directors give consent to increase their liability. If they give the consent, if they are ready to take more liability, then okay, fine, you can change the liability clause. But you cannot minimize the liability. You cannot decrease the liability. So liability clause can be altered only to some extent. Then how about the capital clause? The alteration can be done by passing an ordinary resolution. However, the reduction in share capital requires passing special resolution and confirmation of the court. So for alteration of capital clause, the capital clause can be altered in following ways. That is to increase the authorized capital by issuing the new shares, to consolidate its shares into shares of larger amount, to subdivide its shares into shares of smaller amount, to convert its fully paid shares into stock, or for that is convert the stocks into shares, to reduce its share capital. So these are the things which can be altered. An increase of its share capital by issue of new shares, consolidation of existing shares into shares of larger amount, conversion of fully paid shares into stock, cancellation of unissued shares is also possible. These are the possibilities of conversion of memorandum of association. So I hope you have understood by this time that name can be changed in three situations. That is one, when the existing name of the company is similar with that of another company, then it has to change. Otherwise, if all the shareholders are wishing to change the name, then it is possible. Or when the government itself is instructing the company to change the name, then it has to go for. But for all such things, it has to conduct the shareholders meeting, and it has to take the earlier permission, prior permission of central government or company law board, then only the change is possible. So as far as domicile clause is concerned, company can change its domicile clause only of three types. That is from one locality to another locality within the same city. In such a situation, it need not ask shareholders consent. It can do it by conducting the directors meeting. But when you are changing from one city to another within the same state, you have to conduct the shareholders meeting and you have to pass the resolution for the same. But where you are changing from one state to another, then from both the state registrar office, you have to take the confirmation order and you have to intimate them. You have to file the documents for the same. But in any way, any company cannot shift its office from one nation to another, from one country to another. You cannot shift your registered office. So liability clause or capital clause can be altered to little extent. So this is how the alteration of memorandum is possible. In my next video, I'm going to discuss about the articles of association and other documents also. So, dear students, find my videos in my channel. Thank you.